Hello! This module is the halfway point for all the training modules. Woohoo! You've learned about pretrial justice, the origin story of the PSA, who should be scored, and how to score the first two risk factors. In this module, we will discuss pending charge at the time of the current arrest. Grab your operational guide and open it to page 11. Question 3 of the PSA asks if there is a pending charge at the time of the arrest. You may ask, what is a pending charge?
A pending charge is any charge that has not yet reached final disposition. A pending charge for PSA calculation is a misdemeanor, felony, or criminal traffic charge. Final disposition is not reached until sentencing, acquittal, or dismissal. A charge that is in some form of deferred status is considered a pending charge. Deferred status can refer to a few things. In Wisconsin, there are deferred prosecution agreements, DPA, deferred acceptance of guilty plea agreements, DAGP, or deferred judgment agreements, DJA, with the District Attorney's Office. In return for successful completion of the conditions within these agreements, the District Attorney's Office agrees not to proceed with criminal prosecution charges, or charges are reduced and/or dismissed. If it is clear someone has entered into one of these agreements, it would be considered a pending charge. If a person is in a pre-charge diversion program, the offense for which they are in the program for would not be considered a pending charge.
One helpful way to determine if a charge is pending is to ask yourself the following questions.
Was the person rearrested for an offense?
Was formal accusation filed by the prosecutor's office that a specific person has committed a specific crime, also referred to as filing a criminal complaint or information?
Did the person have an initial appearance, also referred to as IA?
Has a bail determination been made?
Was the person released and allowed to stay in the community pending trial?
Did the person allegedly commit the current offense while released and in the community? If you answered yes to any of the examples, the person has a pending charge.
There are a couple of other scenarios when a charge would be considered pending. If the current arrest is for a charge of bail jumping, including failure to appear for a predisposition court appearance, the underlying charge for the failure to appear is counted as a pending charge because this has not reached final disposition. If the defendant has a pending criminal or traffic charge that carried a potential penalty of incarceration, jail, or prison, at the time the current arrest occurred, answer yes to this risk factor. If the person meets any of the scenarios we talked about and has a pending charge, the answer to this risk factor is yes.
Let's review the FAQs together. The defendant was previously arrested and is participating in a deferred prosecution program. Now that he was arrested again, it is all but likely that the deferred prosecution will be converted to a conviction. Is this considered a prior conviction or a pending charge?
It remains a pending charge. The deferred prosecution agreement has not yet been revoked, so the offense is still considered a pending charge.
Okay, another question. We have NCIC data, but it's unclear whether the out-of-state offense is a pending charge or a prior conviction. How do we score this?
If you are unable to determine the status of a charge on the out-of-state record, do not include it when scoring the PSA. If it is a recent or serious charge, you may choose to report it to the court and attempt to follow up with the court of record.
Okay, so what about if a bench warrant was issued for a predisposition court event, meaning the case has not reached a disposition? Should this predisposition be counted as a pending charge at the time of the arrest?
Yes, this should be counted as a pending charge at the time of the arrest.
If a person is arrested for an offense that took place 2 years ago, which date would I use when assessing for this risk factor? The date of the original offense or the date of the arrest?
The answer is always the date of the arrest, not the date the offense was committed.
Okay, so a defendant had no pending charges at the time the PSA was completed, but 12 hours later, she was served with warrants that the sheriff subsequently discovered. Should we update the PSA?
Yes, the PSA should be updated if the warrants are for pending charges or the pending charges have an FTA. No other risk factor should be modified unless it was determined that they were scored incorrectly based on the status at the time of the arrest.
If a person was referred to a pre-charge diversion program and is currently in the program, Would you count them as having a pending charge for that event?
No, there was not a criminal complaint filed for that pre-charge diversion. This would not be considered a pending charge.
Okay, while being detained under the current charge, the defendant was served with a warrant he had no knowledge about due to lack of notification. Is that considered a pending charge?
No, if the defendant had not previously gone through a release process or been served with a summons on the charge, it is not considered a pending charge. Without a way to verify that the defendant was notified, it should not be counted as a pending charge.
As you can see, on the surface, some of the 9 risk factors look like they should be simple to score. However, there are many scenarios you may run across needing further clarification. As always, you can refer to your guide, and chances are the question will be answered there. Now that you have learned about scoring pending charge at the time of arrest, let's move on to the next PSA risk factors, 4 and 5 in Module 7.